They say technology makes our lives easier. For work, to learn, to travel, to communicate. But there are things that machines cannot yet do. Things as important as engaging, putting themselves in your shoes, having intuition, or making intelligent decisions. In an increasingly technological world, we need professionals who provide intelligent solutions based on their know-how. Because there are things that technology cannot yet do for you. The human tech.
Good afternoon, everyone. Thank you very much for joining us today on the 17th of July, 2024 at 5:30 Madrid time. And I don't know where you are now based, where you are contacting us, but please send us your questions from now. And just please tell us where you're contacting us from and what the situation is. I'm going to introduce you today to experts in the field. We're going to talk about things you need to bear in mind when doing estate planning in Spain. Is it compulsory to make a Spanish will? How could I minimize inheritance tax? Could it work out now? What will be a possible scenario? Applicable law of your will and appointed executors. And then you'll be able to do questions and answers. I have the privilege to have two very well-experimented lawyers. On one side of Spain, we have the expert Michael Davies. Hello, Michael. Good afternoon.
Hi, Ignacio. Hello.
And the other side of the Costa Blanca, we have Pedro Heredia, international lawyer as well. Hello, Pedro. Good afternoon.
Hi, Ignacio. Good afternoon. Hello, Michael.
Hello, Pedro. Nice to see you.
Thank you very much for joining us today. I know you're both very busy. I know Michael is in a rush today as well. And I know time is limited. We're going to talk, Michael, today about a very important topic that I know you're an expert and you're dealing with a lot of cases in Andalusia. You've been practicing law more than 25 years already. And then I would like you, please, if possible, you start with your presentation about what about estate planning in Spain, wills, inheritance. We're delighted to learn more about all that. Over to you, Michael.
Hello, Ignacio. Hello, everyone. Okay, my name is Michael Davies. I'm a Spanish lawyer. I'm not in my office today. I'm working from my kitchen table because Ignacio caught me on the run. So the subject today, obviously, is wills and inheritance, and that's what I've been doing for almost 30 years now, mainly for expats. So how long have I got, Ignacio, to go through?
Right. I think if you do the presentation in 10 minutes, then Pedro will have another 10 minutes, and people could start sending their questions. And if you're in a rush, Michael, you can leave your email and they could contact you directly.
Yeah, I'll be with you until 6
o'clock,
and then at 6 I have to leave. So, right. Okay, so obviously 10 minutes isn't too long, and this is a very long topic. As you know, we've done lots of webinars on different parts of the inheritance process over the years. So let me just start with the basics, though, for the typical married couple that comes over to Spain, and they're in retirement age, semi-retirement age. They buy a villa in Spain, and let me just go through sort of different recommendations, basic recommendations that I'd have with them as somebody that's been dealing with lots of estates for expats over the years, and I've come across lots of different problems and things that could have been done better, etc. So the first thing is when you're going through the process with the lawyer that's handling your conveyance, you definitely want to talk about Spanish wills. So as I say, as someone that's been dealing with probate for so long, it's a long story. We'll do for an hour, but the basic recommendation is you must make a Spanish will to deal with your Spanish assets. Okay, that's my first recommendation. It would save lots of problems and lots of headaches. Having said that, what's very important, people from the UK, especially in Australia, Canada, don't realise is that unlike in the UK, in Australia, Canada, where you can basically do whatever you want with your estate, you can leave it all to your spouse, to the cat's home, whatever you like to do. Spanish people have got a lot of limitations on what they're allowed to do with their estate, okay? So Spanish people, if they have kids, basically have to leave 2/3 down to their kids. So they can't do what us English would like to do, which is leave everything across to their spouse. So that sounds like a big problem, but it's got a very easy solution. And it's all involved, it's all around your Spanish will. So when you make your Spanish will, you've got the option of using what's called Directive 650/2012 to make a choice of your national law to determine how you can distribute your estate. As long as your lawyer puts that clause into the will, if you're British, you can choose English law to determine what you can do with your estate, and then you can go ahead and leave everything, for example, to each other as a second step down to the kids, as most people sort of would do in the UK, and it avoids an obligatory heir claim by the children. Now, there are some people that have not done that over the years, and they have got into tremendous trouble because later the kids have made a claim, children from their spouse may have had children from another marriage, and it causes all sorts of problems. So always make the choice of law. Under this directive, and since 2012, if you have not made that choice of law, automatically Spain's going to apply the law of the last residence. So that means that if you're a resident in Spain and you haven't made the choice on your will, and you've left everything to your spouse on your will, but you have children, that part of that will is going to become invalid because you wouldn't be able to leave everything to your spouse if you haven't made the choice of law. So, conclusion to this sort of quick story is that if you make a will in Spain now, most lawyers that handle your conveyance will already know about this directive and will make sure that happens correctly. If you've got an old will made before 2012, definitely go and speak to your lawyer and revise it to make sure it's in good order. If you want to learn more about this, simply Google Directive 650/2012, and it will give you you'll find lots of explanations from different lawyers about this topic that we've just talked about. In other words, it's very easy to solution with a decent will. So that's that on that front. Let's talk about inheritance tax. Sorry. Lots of regions of Spain have now greatly reduced or done away completely with inheritance tax for Group 1 and 2 beneficiaries. So that basically would be spouse and direct descendants. So for example, in Andalusia, where I am, if you receive an estate from your spouse, from your parent, or from your grandparent, if it's less than €1 million, there's no tax to be paid. If it's more than €1 million, or your pre-existing wealth is more than €1 million, then you get a 99% deduction on your final tax bill. So the conclusion, you'll pay almost no inheritance tax. That is now the same in the Valencia region and in the Balearics region as well. They don't have the €1 million exemption, they do have the 99% exemption. Conclusion, in the 3 main regions where people come to retire, Andalusia, Valencia and Balearics, the inheritance tax deal for spouse and direct descendants is now extremely good. So it means that people that deal mainly with estate planning, like me, we've lost a big chunk of our work. But anyway, the end of all this is it's good for all the people that are buying in Spain, which at the end, of course, is good for us as well. So a lot of people ask also, how complicated is probate in Spain? How long does it take? Well, we always say that if you've got a Spanish will in place and it's a mirrored will, one to the other and then down to the kids, and you've got 1 or 2 properties in Spain, a car and a bank account, the whole thing would take about 3 months to wind up. So in other words, much quicker than in the UK. So when the time comes to wind up your estate in Spain, if you've got a Spanish lawyer dealing with the Spanish estate and a UK lawyer dealing with the UK estate, almost for certain, they'll wind up the Spanish estate before the UK estate. What else? Is there anything particular, Ignacio, that you'd like me to talk about regarding the inheritance that comes to mind? Topics.
I mean, if you want to say, Michael, to talk about the limitation they've got to contact and do the probate as well.
Okay, limit. Yeah. Okay. So in Spain, if somebody passes away, we have got a 6 months deadline to wind up the estate and obtain tax clearance. If the inheritance is complicated, for example, in all cases where there's no Spanish will, we'd automatically request the extension because it will probably be needed. And the condition of the extension is you have to request it within the first 5 months. So we've got 6 months to wind up the estate and pay the inheritance tax, or unless we request an extension within the first 5 months. If there's no Spanish will, in other words, you have to deal with an English will, or it's an intestate process, it's always going to be granted. So if you've got any doubt, your solicitor should make an application for the extension, and that's the end of the problem. So basically, the other thing is that a lot of people say, well, I've been told that if I have a will in the UK, I don't need a will in Spain because I can deal with it all under the UK will. Yes, It's not obligatory to have a Spanish will, even though some of us think that it should be obligatory because it will save people problems. There are lots of things in life that are not obligatory, but they're highly convenient. Well, Spanish will is one of them. If somebody comes to me and they haven't got a Spanish will, first I've got to prove there's no Spanish will. There's a process to do that because we've got a centralized register. But then I've got to wait for the lawyer in the UK to wind up probate in the UK and then go through an expensive and long process to convalidate the will, the English will, over in Spain. I can't even start the process until probate has been obtained. Very often, the UK will contain certain wording that doesn't work well in Spain and creates all sorts of problems. For example, the word trust is very usual on an English will, and that is an absolute nightmare when it comes to convalidating it for use in Spain, because trust, as they do exist in the UK, they don't actually sort of work in the same way over in Spain, and it creates lots of problems, both to actually be able to wind up the estate, but also with Inheritance Tax Office. Again, that could be a whole new webinar just on the problems of trusts in Spain. Over the years, we've dealt with lots of these estates involving English trusts, and we're talking about spending a lot of money and lots of problems. So you don't want to go there. Make a Spanish will. If you've got no will at all anywhere, then what's going to happen is this. The first thing we'll have to do in Spain is work out which law is applicable to the estate. And the intestate rules in Spain are completely different to in the UK. In the UK, when somebody dies intestate, the lion's share of the estate goes to the wife. In Spain, if you die intestate, the lion's share of the estate goes down to the children. So that's the first big shock normally for the widow. And then an intestate process is simply just much more expensive, has a lot more uncertainty around it. And again, you don't want to go down that road. So the long and the short of it, if you're going to buy a property in Spain, inheritance, neither the actual process or inheritance tax are no reason to not buy a property, because it is really, really straightforward in Spain, the probate process. As long as you use a lawyer that deals with these sort of things, you'll have no problems at all.
Michael, Shelby is asking, can you exclude family members in your will? I think you did cover that, but could you clarify that according to the applicable law?
Yeah, absolutely. So the first thing is, it depends on your nationality. Okay, so if you are from a country where you can exclude, for example, your children, like the UK, then you'll have no problem. You make a Spanish will and you state on it, conforming to Directive 6/2012, I choose my national law, English law, to determine how I can distribute my estate. And then if in the UK you can leave your children out of the estate, then you can do it on your Spanish will. Now, if you're from another country which has obligatory heirs, for example, like France, and you're French and you come over to Spain and you make a Spanish will and say, oh, Michael, I don't want to leave anything to my children, you're not going to be able to, because if you choose French law, you're going to have a similar situation with different percentages than you would in Spain. And as far as other family members, again, I mean, under Spanish law, you can exclude cousins, etc. You can't exclude the children, the spouse. Children and spouse were basically the two that you can't exclude in Spain. Lots of countries in the world where people are coming from when they come over to Spain don't have obligatory heirs, and some of them have actually systems that actually the obligatory heirs are the actual spouse. The southern countries, basically France, Italy, Portugal, Greece, maybe the other one, they're mainly these countries that come from Roman law. Most of them have systems that basically protect the children. So those are the ones that cause problems when you want to leave everything to the spouse.
Okay, that's very good, Michael. And one very last question for you. I know you've been acting as executor as well. Will you say something about the NI numbers? That's something that a lot of people get stressed about, the beneficiaries getting the NI number. Can you explain how you do with power of attorney, etc., etc.? Yeah, okay. I mean, so the request of NIE number is not a problem. Otherwise, nobody needs to worry about it. In about 80% of our wills, we're named as executors. So if we're the executor, we can actually wind up the estate. But strangely, even though that's all powerful things, because you're winding up estate, you're changing the deed into somebody's name. Something as small and significant as requesting the Spanish tax number, we'd actually need a power of attorney for, and can't do it as the executor. It sounds really silly, because it's like you can do the really important things and not the smaller things. So
nowadays, what we do to save that problem, that obviously from the question I can see you must have come across it as well, is automatically, even though we're executors of the estate, we automatically, wherever the client is in the world, we send over a power of attorney and have it signed. And that power of attorney includes the faculty to request the NIE number. We normally take the opportunity, obviously, the client has decided, the beneficiary, they may be selling the property after they inherit. We also take power of attorney to sell the asset at the same time.
Actually, Michael, I will add a little bit more into that. Recently, I don't know whether in Andalusia you've come across this, but the notaries, when we go and complete, they could apply for a provisional NI number. Have you come across that? Because in this area, we have, thank God, that at the moment, it gives us, whenever we cannot get the power of attorney, we could get a temporary one, and then eventually that NI number is only to pay the inheritance tax. But you need to go to the immigration to make it a final one. Otherwise, it's just to pay a number. That was an issue in the old days, wasn't it? When we had children, grandchildren.
Absolutely. So basically, I mean, normally we don't, unless it's somebody that's hired us or very late in the day, normally we haven't got like a deadline problem, because normally, we start working within the deadline. But if we were about to hit the deadline and go over the 6 months or the 12 months, if the extension has been requested and there's no NIE number, then basically we've got sort of three ways that we can sort of play around with it. One would be the normal way and have the NIE number in place. If we haven't got the NIE number, the notaries that we deal with will allow us to sign the probate deed and provide the NIE number later. But of course, so it gives me a little bit of window, a bit of extra time, but I'd still need to pay the actual tax, or even there's no tax, just to present the liquidation request and no tax is paid. So I got lost on trying to say an email was clicking through on my system at the same time I was talking. So in those cases, yes, we can. We also requested a provisional NIE number via the notary, so that we can actually either pay the inheritance tax or declare it exempt, so that we can get through that. But we very rarely do that, because normally the power of attorney we get
power of attorney,
and the NIE number at the moment is taking maybe 3-4 weeks at most. So normally it all works out.
I find it very handy, Michael, especially when it's difficult, especially if the will says children or grandchildren, and getting organized power of attorney from parents on behalf of the children as well.
Yeah, absolutely.
And this complex, I had a case like that it was a kind of a nightmare because of the NI number. I fully agree with what you said. You've got power of attorney, you're the executor, you could do everything, but then you get stuck with the NI number. Nowadays, at least in this region, that avoids, and to be honest, it was only to pay tax, which was 0. So it was more an obstacle rather than anything.
There's just a red tape. It's a red tape. No, it's a good solution. It is a good solution. Absolutely. Yeah. And over there, I presume you do it like here. Yes, you request the provisional NIE number via your notary, don't you?
That's correct.
He requests it for using his digital signature.
Yeah, that's correct. And at least you have something to pay the tax. And if they're not planning to do anything else, well, at least you've got it, but that's not a final, is a provisional NI number. You'll need a power of attorney eventually, but at least you put the ball rolling, Michael, because you will sell it. You will need that NI number as well eventually, but at least you don't get stopped because of 9 grandchildren trying to organize 9 power of attorney from parents with the grandchildren that on behalf they're able to complete and to sell. And I'm talking about complex scenarios. Okay.
Yeah, absolutely.
Michael, could you please send us here on the chat your email address and website as well, just for those who wants to watch more videos or more information, because I know you're running out of time. And I'm going to pass over to Pedro now for what he thinks, the things that he needs to bear in mind. Well, we need to bear in mind when doing estate planning, and how important that is. Michael, is there anything else you would like to add on? Because of
the only thing I'd say, just simply because I came across a case this morning, and I've seen quite a few, is just beware of financial advisors selling products on the back of it's saving inheritance tax in Spain, because we're seeing a lot of abuse in this. We're seeing a lot of sort of people that don't really know what they're doing, or they do know, and they're sort of playing around with it. I'm not saying all the financial advisors are selling products that they shouldn't be doing, but I think if you want inheritance tax advice, go to a lawyer that's not selling any products, not selling the setting up of companies, not selling any financial products. Have an a consultation with a lawyer like me, or somebody that's not going to sell you an expensive setup, because we've seen some of these setups, both the variety, where they include complex company formations, etc., putting property in the name of companies, etc., and financial products in different nature, with the life insurance policies, etc., life insurance wrappers. And we've sometimes seen people get into these complex products. They don't actually save them any money in reality. It sort of traps them into a lot of expenses. So I just say, pay whatever it is, a lawyer like us or like you, just to go through the situation, because you may not need anything complex to save inheritance tax in Spain, especially if the beneficiary is going to be spouse or children.
I fully agree, Michael, because you end up listening on the radio and these and the other about saving tax, and there is always attached a product there that they say, well, if you do this, you save tax. Well, it's not really completely true, because that's one of the products that might fit into you or not. But the best thing they could do is go into an independent lawyer, doing tax planning as well, and see what is best. And then from that on the table, you choose whatever variety of product you have. I fully agree. And but people are probably being aware now more than before in the old days, Michael, that they need to go for independent advice. And I agree. Okay, Michael, thank you very much. I'm going to pass over to Pedro. Hopefully see you soon on the next webinar, Michael, if you can
I'm going to be with you for the next 10 minutes, and then I'll switch off.
Oh, great. Okay, if you jump on something, then I'm going to pass over to Pedro now. Pedro, let's start doing what about estate planning? Could you please add any good information for people?
We have one of the latest questions by Eunice, says, being domiciled English, can you leave worldwide assets to children in a Spanish will if you are resident here, I presume in England, in the UK? That's a very good question. I can read it, Michael.
Which one are you talking about, Pedro?
What time is there? What's the timestamp?
5:51, 17:51.
Oh, there's like hundreds of questions here. Which 5:51? When you say come over to Spain?
No, being domiciled. Well, that one also is okay. Yeah.
Okay, so do you want me to take it, or?
Yeah, sure.
Okay, so with inheritance tax, I'll just give you a bit of a, so that I don't just specify with that question, it helps more people. But basically, the way it works in Spain is this. If the beneficiary is a resident in Spain, he's got to declare to the inheritance tax office what he receives worldwide. Okay, everything it receives worldwide. If he is a non-resident of Spain, in Spain we will have the beneficiary has to declare what he receives in Spain, plus a product called Spanish compliant bonds, which is like the exception to the rule that even if it's in Ireland or whatever, it's still considered to be in Spain. Remember that apart from the situation in Spain, which is what the lawyer in Spain would be dealing with, you could have an issue in the UK as well, which has a completely different system. And you can actually be in the UK, have left the UK, and still be deemed UK domiciled, and therefore they may be after inheritance tax from you in the UK as well. But you need a consultation with an English lawyer to discuss that side. From a Spanish point of view, if you come to me, you're the beneficiary of an estate, I'm going to ask you whether you're resident. If you're resident, I'm going to declare in Spain what you receive worldwide, both by any Spanish will, any UK will, whatever you receive. If you are non-resident, I'm going to ask you what assets have you received in Spain, and those are the ones I'm going to declare to the Spanish Inheritance Tax Office. As simple as that. But remember, you've got the other angle to this, which is the angle from the UK that you'll need to look into with an English lawyer, because as we always say, yes, we know quite a lot about how it works over there because we're always in contact with English lawyers. But for compliance reasons, we can only advise on Spanish law because we are all Spanish lawyers, not UK lawyers.
Good. Pedro, would you like to just carry on with questions and answers, Pedro?
Yeah,
would you like to stop?
Let's go through the questions and answers, and through that I will be explaining anything that I may consider in this way. I think it's going to be better than I do. Okay. But
let's go for it.
Usually by June I think it's been answered, but let me just clarify some points in as a being domiciled English. obviously, if you are resident in Spain, at the end you declare your worldwide assets and you receive an inheritance as we are resident in Spain. If you are not resident in Spain, if you are resident, you declare according to the Spanish rules and according to the region where is based the assets. For example, if the property or an asset it is in Comunidad Valenciana or in Andalusia, will be or the national rules on inheritance, or maybe the Andalusia rules or the Valencia rules, where the property is, obviously the one which is benefit on that. If it's, imagine that you have a property in Balearic Island and also in Comunidad Valenciana, which is two different regions, where it's applied the inheritance rules, will be the assets who are more valuable in that case. That would be the rule to apply. Okay. It says in Spanish by Shelby, thank you. It says in Spanish, will can you designate the amount percentage of cash funds each family member will receive? Or is it equal percentage for each? Okay, let me show again something that has been said by Michael, but let me just clarify again. If I can share that. Okay, can you see this page?
Yeah,
right now?
that's
Okay.
good. Yeah.
So this is what Michael has said at the beginning. Sorry, let's go. It says
Article 22, Pedro?
Yeah, 21 and
Okay.
22.
So it says 650 2012 of the European Parliament, which is jurisdiction applicable law. So an applicable law, as it says by Michael, Article 21 and 22. Let's go those articles just to read them, just to understand why it's important. It says the general rule basically says, unless otherwise provided for it in this regulation, the applicable law to the inheritance as a whole shall be the law of a state in which the deceased has his habitual residence at the time of death. So if someone moves into Spain and is resident in Spain, his habitual residence at the time of death may be obviously Spain, because he's resident in Spain. So the applicable law in this case would be a Spanish law. Spanish law has some obligations and limitations on saying that 2/3 of the assets goes to the children. Unless there is no children, there will be some other percentage, 50% to the parents. If there is no parents, there will be some all kind of freedom in those cases. But obviously, there are some limitations on descendants of 2/3 of the assets. I always put by example, I'm married, I have 2 children, I cannot give everything to my wife. 2/3 of my assets goes to my children, and this is what it is. So I have the liberty to decide and move, and obviously doing in a Spanish rule 1/3, and some other situations that we can play. But as Michael and Ignacio says, Article 22, the choice of law, those ones that move into Spain and to be resident in Spain are residents in Spain, but the foreigners are no Spanish citizens that have a different passport. It says a person may choose as a law to govern his inheritance as a whole, the law of the state whose nationality he possesses. Nationality he possesses, which is your passport. At the time of making the choice or at the time of death. Normally it's it says at the time of death. So if you at the end of in that way you are British or from Germany or from Switzerland or wherever, I mean, and the limitations on liberty are better in those countries where you are citizen, where you are, when you possess the nationality of those countries or that country, then you may choose the law of that country in order to benefit your situation in terms of choosing the beneficiaries. Okay, I just wanted to clarify that. Okay, and
that's quite interesting.
Okay, that is the law that is governed and this is not Spanish law, this is European law. This is European law.
Yeah,
it doesn't matter if you live in Spain or in Italy, or I mean, the countries that are binded are all over the European Union, in this case, except, I think it's except Denmark, if you live here, you are resident in Denmark, and Ireland. I have not seen if he's been checked. So even though you are from Japan, or from Australia, from the United States, and you live in Spain, that law is compulsory to you. So you come to Spain, you are resident in Spain, will be a Spanish law, and unless you choose your national. Okay.
Yeah, but this is a very good question, Pedro, because a lot of clients say, well, I'm the UK, but the UK never signed that agreement. It doesn't matter. If you're
Doesn't
a
matter.
resident in Spain, I mean, you need to focus on being resident. Spain did
Resident.
sign this
Once you
agreement,
become resident,
therefore this is applicable.
Yeah. So the
Correct.
deal with that's a question that lots of people ask. So they don't need to worry. Basically, Spain ratified the directive regardless of reciprocity. So it doesn't really matter whether the other country ratified, didn't ratify. It makes no difference. No difference whatsoever. Spain will apply that national law. I'm going to leave you now. I can see my carpenter has arrived. I've got to leave you. My dog's telling me there's someone at the door.
Okay.
Nice to see you all.
Speak to you soon.
Bye.
Right. So Pedro, so this is quite
let me
important
just go
topic.
through the question by
Yeah.
Shelby. I mean, obviously, through the Spanish law, obviously you have some invitations, but obviously you choose. I don't know which is your nationality. But let's put the example that is British. So you are able, you will be, you have 100%. Well, there are some limitations also in English law, but let's say 100% liberty to decide whether you want some percentage to someone or some percentage to someone else, and you will be able to choose that. So perfectly with a will, but says expressly that the national law that you choose has the possibilities to do this kind of distribution on this. Okay.
So to the question of percentages, the answer is yes. She could put in the will, and we've done it, Shelby, very much in the wills. X% to my husband, X% to my children, X%. So that's not a problem.
With friends, with like 10%, or always sometimes there's a legacy of a specific asset, a property, a jewelry, or anything. I mean, obviously, you can with liberty. Obviously, we've made wills like I remember sometimes that we made wills like 15 pages. Probably is the most extensive one, but at the end you can do distribution on anything that you may want to and at the end decide a lot of things that you could think about.
Pedro, Stuart has a good point, because he says when you say come over to Spain, you mean for residencia. But the thing is, this is the situation, Pedro, could happen even you being fully legal resident in Spain, or even you passing away while you are being non-resident. Okay, so the important thing here, Stuart, is to make a will. Whether you are resident or non-resident, it doesn't matter, because it's important you make a will. This is something very important advice. If you don't have a will, then the applicable law, and you are non-resident, will be your nationality. But that brings a lot of more complications, as Michael stated, and Pedro, because you need to bring more paperwork. The probate in the US, I think you're telling because you are in the US. I'm not sure, Stuart, if you're contacting us from the US or UK, but nevertheless, it does apply exactly the same. Bear in mind two things. I passed away being non-resident, non-tax resident, or not having residencia. Okay, and I never made a will. That's an issue. That's an issue. That's going to be a complex inheritance. That's why we're recommending you to make a will according to your national law, or the law that you think is best suits you for your own interest. Now, it's important more than ever, wills or you haven't made a will. Okay, that's the key. Whether you're a resident or non-resident, that limits the inventory of the probate. So if you're non-resident, as Pedro Michael stated, you will only disclose in Spain the properties, assets, and movable assets that are in Spain. And the rest, it will be governed by your personal law, your national law, and you'll have to do probate. Well, the beneficiaries will have to do probate in your home country. Now, if you are resident, that's what Michael was saying, you will have to include worldwide assets, and probably here, the tax will be 0 or minimum, okay? So this is something we'll have to discuss once we disclose all the assets. But the bottom line here, even though if you're resident, and obviously, again, the number one advice is to make a will. If you don't have a will, it has a different impact than what will be the applicable law. Now, if you're a resident, and I think this is quite important for you to learn here and everybody to learn, if you're a resident, you never made a will, you might have an issue because you didn't give instructions to anyone and neither left instructions who's going to be the beneficiary. And if you haven't said anything, you haven't made a will, and the directive that Pedro just mentioned, you didn't choose what applicable law, then it will be the Spanish law applicable here. And that probably is going to happen, something that you don't want. You're going to give 2/3 to your children and 1/3 to, probably will all go to your children, and your husband or wife will be, and will have the life interest. So I think, Pedro, this is quite important. On one side, non-resident and resident, that is about disclosing assets and tax implication. And the other thing, and the most important thing, is about choosing the applicable law, which, whether you're resident or non-resident, we highly recommend you to make even a simple will, because sometimes you could say, well, I'm not sure about this. Well, just do a simple will. And if you need to change it, then do it whenever you have more time to do it. Okay. But I think I wanted to bring this because it's important. It's not about coming over to Spain, but it's more about resident or non-resident, and will or not have interstate. Okay, Pedro, over to you. Please, please carry on.
There's a really quick question regarding the Anne and Graham is saying about the Spanish granddaughter living in Spain who has some mental issues, health issues, and is over 18 years old. He's around 24 years, and also they have some other granddaughters, and they're going to move to Spain. They're going to move to Spain, and obviously something that obviously when we said you're going to move to Spain, obviously there will be some limitations on whenever you become resident in Spain. So it's a must. In this case, I would say a must to make a will in Spain in order to decide what will be the applicable law in this case, just to have liberty of you possess the English passport nationality. Then in order to obviously to provide to the three granddaughters, what are you going to give them in terms of protection with them? And in this point, I would say that it's extremely important to choose this executor. At the end, if you're going to protect and take care of one of it, in this case, one of it granddaughters, which needs some help, we need some protection, independent protection in terms of executor, is something important. Ignacio and myself, we've been dealing with as an executor with many wills, and right now we are officially on the list of executors in Comunidad Valenciana. And obviously, in this case, an executor, if your granddaughter lives in Spain, someone here, if your granddaughter lives in the UK, probably an executor that is living there in order to be able to use this power in order to provide them. But it's extremely important to do that way. Obviously, in terms of inheritance, if they live here, the Grupo 1 or Group 1 and Group 2, deductions on Comunidad Valenciana, I'm talking about Comunidad Valenciana, which is Alicante, Valencia, Castellón. The deductions are quite big, and obviously the reduction on percentage of a QOT to be paid is 99% deduct. So it's a lot of reductions, which is very good for descendants and also grandchildren. So it's really good on this, but obviously the assets, it's always the estate planning. In this case, Ignacio and myself, we speak about where are the beneficiaries and where are the assets. If the assets are in the UK and the beneficiaries are in the UK, then will be UK inheritance tax in order to provide. If the beneficiaries are in Spain and the assets are anywhere in the world, obviously, as a resident in Spain, will be providing inheritance tax worldwide assets that they receive an inheritance. So it's important to know where the assets are and where the beneficiaries are residents in this case.
Mm-hmm.
Okay,
Pedro, I've got one here from Rick Winders. I think I know them. I think we've been dealing, Rick, with your parents, mom and dad. Yes, I know. I think mom is Spanish, dad is English. They live in Alicante, and they have assets in both countries. As far as I know, they've done wills in Spain, and I think they've done a will in the UK. But I'm not sure. If you wish, we could double check that. They could have a will in the UK only for UK assets, or in the US, or around the world, and they could have only one will for Spain, unlimited. But Pedro, I have a good question for you. Well, for us, which I think Shelby brought it very interesting. I mean, Shelby, when you say Spanish citizen, I'm not sure if you're saying a nationality or a citizenship, because if you, Pedro, Article 22 or 21, if you read the Article 21, it says you could choose the law of any state that you are. But let's say I am Spanish and I am American. Okay, I have dual nationality. I have two passports. She's got pretty much this question. If I'm considered to be American, do you understand, Pedro, that she could do the will according to the American law, even though I'm not sure if it's the case here, but it could be the case.
Look, the article I'll just write it down in the chat so everyone can read it. I will read it if that person is not on the chat. It says a person possessing multiple nationalities, in this case 2 nationalities, may choose the law of any of the states whose nationality possess at the time of making the will or at the time of death. So we'll be able to choose, or in this case, or American or Spanish. The other question that maybe said is like, because many people we see that they have like, oh, I have 2 passports, I have 2 different nationalities. Well, in many occasions, it's not like that. In many occasions, well, you play with that, but you have just 1 nationality, really. Because Spain has convention with many countries in order to have double nationality, but with most of the countries do not.
Right, so that's the answer, Pedro, isn't it? I mean, there has to be recognized the dual nationality, because if it's not recognized, Spain will only consider like Spanish.
Yeah.
And it wouldn't make sense making. But I think the case for Shelby, I think she's American and permanent resident in Spain. But Pedro, if she was, let's put it this way, which I think it could be a very, very normal case. I'm American, I'm Spanish. In this case, do you think that we could choose, because having dual nationality?
In my opinion, be practical, yes. I can say yes. And obviously, we like to be accurate on all the information and be practical on terms of what will be the scenario whenever something happens, whenever someone dies, and whenever the beneficiaries are gonna get the assets. And obviously, as we've been in many litigations on inheritance, obviously in order to prevent and guarantee that at the end there's no litigation, or if some beneficiary is going to start any claim, obviously the arguments against that will be won. We include some clauses in the will sometimes in order to someone start litigations just to reduce in the Spanish law or reduce some penalty clauses in order to do that. But yeah, I mean, in terms of that, I would say, well, you choose your nationality, whatever you understand it is, and obviously, I will like to see if it's correct that the nationality you already think that you have. Okay, let's go to another question. I think it's been said, but it's always a question, always about the NI number for the beneficiaries. It says from Gerald, will any heirs who live in the UK or USA need to have an NI number? We have UK and Spanish wills. Will you test to look over them? I mean, obviously, it's something that we do a lot, just to check the wills. But in terms of NI number, I mean, you have chosen some beneficiaries. They do not live in Spain. They do not have NI number, obviously. You don't need to get them now. I mean, it will be got. Someone will, I mean, a lawyer will be got whenever it happens. Whenever someone dies, there will be starting a process of inheritance, and that will be the time in order to apply for the NI number. At this time, there is no need to get a NI number for the beneficiaries at all. Okay, so it will be in the time when someone dies. It will be the time in order to, okay, who are the beneficiaries? Do they have any number? No. Well, let's get them, and will be the way to do it in that way. Okay.
Good. Right, Pedro. So another thing Rick Vindez was asking is it a possibility? I mean, I didn't comment this, but you could do in Spain an international will. What does it mean? You could say you're British, you're American, whatever nationality you have, and you want to discuss, well, you want to live with regards to worldwide assets. So is it possible to refer everything? Is it possible? Well, probably he's saying, is it possible to make a UK will in Spain? But in Spain, it's possible to do an international will. What does it mean? You do a will, and you talk about that this will applies to worldwide assets. In the UK, you will still need to go through probate to legalize that will, but that's a different story. Is that will valid in Spain? Yes. Will you need more evidence eventually in the probate? Well, I don't think you'll need more evidence than an affidavit by the notary and the lawyer that's been dealing with it, and a witness if necessary. Another question as well, Pedro, is about executors. Could I have executors in the will? Well, I highly recommend this in 2 occasions. One, if you think it's going to make life easier for everybody else, okay, so that's a good one. 2, if you don't have, if you really need to leave everything to third parties and you want somebody independent to do the job, that's very important. Could you have jointly and severally as executors? Yes. Okay. Actually, we have cases that people leave everything, so husband to wife, wife to husband, and later on goes to charity, and then cancer association or whatever. We're the one who sell the property, pay all the debt, existing debt, and whatever is left, residual value on the assets, then we transfer to the charity where you go. It is important, as Pedro said before, you disclose all your assets to the executor, because otherwise will be lost eventually. And unless the beneficiaries know where to contact, if we don't know, it is very hard to do private investigation about what banks you were using, what properties you had around the world, etc., etc. Pedro, would you like to pick up the another question, because we're getting hundreds of questions here.
From Edward, how does Spanish inheritance tax work, where the person who has died in the United States and the property being left in inheritance is in the United States, and the property being left in inheritance in the United States, and one of the beneficiaries, a child of the deceased, is resident in Andalusia. So at the end, property in the United States, the deceased is in the United States, and one of the beneficiaries is resident in Spain. So it see as whoever is resident in Spain, whoever is resident in Andalusia, whoever, it will work the rules of Andalusia rules. In this case, they had a big relief. According to the probate, the wills, the documents about inheritance, in this case of value of the assets and minus the charges, which is the net amount, which is the percentage on that, is going to be received by this one, will be paid according to inheritance tax, according to whoever is going to be received by this resident in Andalusia. Okay, and that's just that. I mean, obviously, the transfer and transmission, if it's a property, and some percentage needs to be obviously changed in the ownership of this resident in Andalusia and put the name in the property registry, this comes obviously the rules of the United States. So you will have to give power of attorney to the solicitors in the lawyers in the United States in order to accept and obviously change the name of a property in the United States. But in terms of inheritance, it needs to be created like a document with the documents from the United States about the values, what is going to be, and obviously pay taxes. No, at the time, in order to voluntarily pay taxes and declaring taxes in inheritance in Spain is 6 months from the date of decease. But, and this is something that in international inheritance files happens a lot, the complexity of the value on creating obviously the beneficiaries and get all the documents, and it creates extensions. During the first 5 months, you can apply to tax office to make another extension of 6 months. So you will have time, 12 months, in order to obviously to declare and pay taxes without any fine or interests. Well, sorry, interests will be included in that, sorry.
Pedro, I think you answered the question from June. Being domicile English, can you leave worldwide assets? Yeah, I think you did cover that, yeah?
The scenario of a married couple by Fulvia. The scenario of a married couple, Spanish residents with no children, no surviving parents, and the Spanish law will the spouse automatically be the only one. Obviously, in the Spanish law, we say descendants, ascendants, and widow. The third step is widow. Descendants, ascendants, widow. And they say there is no descendants, there is no ascendants. Spanish law, obviously, the third step is the widow. And will be automatically without any will, without anything. This is Spanish law in case that you don't have a will. But obviously, the will The limitation obviously is on the on this. But yeah, that's correct. Will be we obviously will be automatically be only the beneficiary.
Mhm.
What else? There's hundreds of questions. Let me just read.
I mean, the bottom line, while you're going through, Pedro, to summarize here, we highly recommend you to make a will, whether you're resident or non-resident. If you have the nationality that you're entitled to choose the law, we encourage you to choose the most beneficial laws for you and your loved one. 3, we encourage you as well to do, when you do the appointment with the lawyer, to do the most tax efficient way of distribution to the time where you are doing the will. And 4, I think the executors could be a good help for you. Could you do international wills? Yes. Could you cover all Spanish assets and worldwide assets? Yes. Could you leave percentages and leave X amount for charity? Yes. So there is, but only if you make a will. That's the important thing. Do you have to make a will? No, you don't. Is it highly recommended? Yes, because it really protects your wishes. Otherwise, there is no wishes, register, and the will in Spain will be signed in front of a public notary. And in the meanwhile, the notary will send the last will registry in Madrid the information, not inside, not what is disclosed in the will, but about that you've signed a will. So if by any reason, it's a very secure system in Spain. If you have lost your will, if nobody knows a copy of your will, if let's say there is no way to find it, there is always in Spain a way to find where your will was made if you ever went to a public notary. Why? Because the notaries disclose that you've signed a will and this is your last will that is being kept in their notary office and in the library of the law society after the notary moves offices. So all these documents are 100% guaranteed. Nevertheless, I encourage you to have a copy and give it copies to your lawyer so we can scan it in the file, and children might have a copy as well to make it easy and identify. Pedro, which one you found
Okay,
here?
let's say my children are beneficiaries under my Spanish will. They are UK residents. Do they need any number? No. I mean, if they are not going to receive anything in Spain, so they don't need it. Mihaela, do I need to sell the house to give half to my son-in-law when my husband passes away? If your husband passes away and gives everything to you, obviously you will decide whether you want about your assets. If your applicable law, in this case, it has 100% liberty to do it. If not, if it's a Spanish resident and Spanish law applies, and your son-in-law, if the son of your husband, will receive, obviously, according to the legitima, as we say in Spain, which will be 2/3. Obviously, if you have a will, then you will be able to choose, obviously, your nationality law. That's what we are insisting on this, but it's extremely important on this. Okay.
And it is important, Pedro, it is important that they do an exercise on what is going to happen when.
A simulation,
because
that would be fantastic.
Because the situation here, Pedro, is depending on your will, whether you made a correct will or of interstate, is going to have a lot of implications. Civil implications, who are going to be the beneficiaries, who are going to be joint owners of the property. That's an issue. And 2, the taxation. Because if you're going to leave it to a lot of people, what is the relationship you have with that people?
That's important. I mean, just one example. We have clients that they say, okay, well, we are going to children in most of the occasions. I would say that they don't want to enjoy. No one of them wants the property and they want to sell the property and get the money. So it's important to plan. It's important to make some simulations. So, okay, what kind of tax are you going to pay on inheritance tax? And what kind of tax are you going to pay whenever you sell the property on capital gains? Because in many occasions, now that we have a really good benefits on law on inheritance tax in Comunidad Valenciana, in Andalusia, in Madrid, if you may pay a very little amount of inheritance tax, obviously increasing on market value, really on market value of the property. So imagine that you receive a property which in market value is 300,000 euros, and you have to pay a small tax on inheritance. And this is important to check what kind of tax you're going to pay on inheritance. okay, if you're gonna pay a small tax, but whenever you sell the property, obviously you will sell it for 300,000 euros, there will no capital gains tax, so zero tax to pay on capital gain, and at the end you pay less. If you are in a region that maybe you pay a lot of inheritance tax, the property is there, in, for example, in north of Spain or eastern in Catalonia, or then you need to obviously play a little bit with the numbers. Maybe sometimes there are some limits on tax reference, on tax value. You cannot cross that line, but obviously whenever you sell, you will also pay capital gain. So it's something that is a calculation, a simulation that needs to be done in terms of it is better to pay sometimes a little bit more on inheritance tax because you're going to save a lot of money in the future whenever you sell a property on capital gains.
That's a very good point, Pedro, because as you explained, if you really, and this is all about estate planning and tax planning, if legally your property is worth X, but probably if you under-declare that, you're going to be hit in the future on the sale. And it's very, very recommended to declare it the high value. There is probably no tax to pay, and eventually you will never make a capital gain tax. So that's one of the very important things to do. And I recommend you to do that exercise with a lawyer. Now, John, hello, John, he's asking, does the inheritor have to pay the tax due before they can take possession I think it says of the inheritance. John, no, possession of the money will be, if the money is in joint names, as soon as the bank knows about it, they will freeze 50% of that, but they will still allow us or the beneficiaries to direct debit the inheritance tax into their account. So, but you don't lose possession of the property. The property is still in joint names. You're going to carry on having the use of the property. The only thing is, as soon as you disclose that information to the bank, they will freeze it. My recommendation here: you speak to your lawyer whenever that happens, and don't go too quick to tell the bank, because they try to protect the beneficiaries. And probably what you're doing, you're going to get that anyway, but it's making your life a bit more difficult. We normally disclose that information in front of the bank 1 week probably before completion, when we're going to complete. But at least you have enough time to work out all the ins and outs. Pedro, we're having hundreds and hundreds of questions.
Yeah.
Is there, I mean, my advice for them is to organize an appointment. This is like doing estate tax planning, doing will planning. I think it's peace of mind. And the most important thing is that according to your wishes, that will be performed, and obviously in a tax efficient way. My recommendations, just review, just have a will, at least one, and try to do things as possible, as good as possible, just to avoid further problems. Is there any way, Pedro, is there anything else you would like to add here? Because obviously we're running out of time, and we still carry on having a lot of
Yes, we recommend obviously prevention. Let's recommend, because we have many clients that thought the taxes on inheritance were quite big, and obviously the rules have, even though the rules have changed a lot. Before that, it was not too much, but now it is very low right now in inheritance in Grupo 1, Grupo 2, which is ascendant descendants and grandchildren and partners, spouses. But obviously, it's just to recommend to know what will happen, what would be the tax to pay by the spouse, by the children, by the parents, by the friends, by whoever is going to be the beneficiary, to understand what will happen. Obviously, to plan with a will, which is obviously it's not an obligation, but we say many occasions is really a must in order to do it, in order to reduce or eliminate any complexity on the inheritance. And obviously, this combined by the will, by the inheritance tax study, obviously creates like a guarantee, creates security, creates peace of mind really on what the beneficiaries is going to receive, and to be sure that they are going to receive that.
Okay, Pedro, thank you very much. Thank you very much, all of you, for listening and learning more about the law in Spain with Pedro, with Michael. You've got all the emails, you've got the website, you could play the videos that we have, and a lot of information here just for you, because we are creating all this content for you to learn before we even need to make the appointment. I'm going to pass over to Juan Fran. He's going to share with you a video, a 1-minute video that really makes a summary of what we could do in case you need help. Thank you very much, Pedro. Thank you, Michael, for sharing. Thank you, Juan Fran. Over to you. See you in 2 weeks' time.
When a loved one passes, it takes time to assimilate losing them. At these times, when you least want to deal with paperwork, Pellicer and Heredia are here to help. One of our lawyers will be in touch to inform you about the process and answer all your doubts on the legalities. No matter where the assets and heirs of the deceased are located, and without having to travel to Spain, we can advise you and carry out all the required proceedings in Spain. Obtain the death certificate. Search for assets, debts, and existing insurance policies. Give advice on accepting or renouncing the inheritance in Spain. Hand over information on all the related costs. Pay all the compulsory taxes on your behalf, and translate all the legal documents required. And remember that upon death, when carrying out all these processes, legal deadlines apply. Through this difficult time, when you most need help, Pellicer and Heredia is with you every step of the way. Pellicer and Heredia, international lawyers.